You may proceed.
Good morning. May it please the court. I'm Tom Cox, and with me is my partner, Marquetta Bryan, with the law firm of Carlock, Copeland, and Stair. I'd like to reserve approximately 5 minutes of my time for reply, but I realize it's my responsibility to keep up with that. We represent Dr. Eugene Walker, the plaintiff in the district court action below, and an elected member of the DeKalb County Board of Education. He was suspended from that office by the governor pursuant to OCGA section 20-2-73, which I refer to here and in the briefs as the removal statute, which is now before this court on a certified question from the district court to determine whether it violates the Georgia Constitution. I know I share with the justices the memory of those law school essay exams where a factual or legal scenario is laid out, and we are to identify and discuss all the relevant issues raised. The statute under consideration here today reminds me of one of those essay questions, as it could well serve as an essay question, I believe, in a course on Georgia education law. And the question would be this: review the board removal statute and identify each respect in which it may violate the Georgia Constitution, and discuss. This is what we have tried to do in our briefs, but before discussing why the statute violates the Georgia Constitution, I want to identify those respects in which it does, because each of those items applies to basically all three of our main legal arguments. First, the statute permits the governor to remove an entire elected school board without any finding or even a charge of individual wrongdoing by any single board member. Second, the removal process is triggered only by the finding of a private organization completely unaccountable to the voters. Third, it sets no standard at all for the determination to be made by the state board and then the governor whether board members, an entire board, should be suspended. It merely says if the state board will decide whether to recommend the suspension. Fourth, it requires at that suspension stage the suspension of all board members or none at all, regardless of any individual board actions. Fifth, it sets a standard then for a board member to get his elected constitutional office back that is arbitrary or impossible to achieve and is based solely on whether the private accrediting agency finds that elected board member preferable to the governor's already appointed replacement. Sixth, it leaves it up to the governor to make that decision on final removal, the governor being the very person who has already decided to suspend and replace the board member. And lastly, gets back to the original point, it puts the individual elected constitutional officer, that being an elected school board member, in the incredible position of being permanently removed from office without ever having even been charged with any individual wrongdoing, much less ever having been proven to have committed individual wrongdoing. Now, with those items laid out, let me turn to why it is then which of these, under these three categories, under which the law is unconstitutional. First, it violates the concept of local control of public education by elected local school boards. That is provided in Article 8, Section 5, Paragraph 2.
Mr. Cox?
Yes.
What would you say are your 2 or 3 primary arguments? One is that, if you would just give your 2 or 3 primary arguments on these issues?
Yes, well, that's the first one, that it violates local control of public education by an elected school board. Second, the state...
You got to spell that out for me, because local school board members unquestionably can be removed from office for felony convictions, right, under Article 2. They can be recalled. So there are various things that can control, that can
Yes,
affect.
okay.
local school
Recall and felony convictions are provided in the Constitution.
Right. So my question is can you spell that out as to why this is not one of the permissible means of removing people from office? In particular, as I understand the state's argument, they focus on the constitutional language that the General Assembly can set additional qualifications.
That was exactly going to be my second point, that this does not, under any reasonable definition of the word qualifications, meet such a standard. That what is a qualification is, as much as the state argues, I think in a very well crafted brief, but I think it's forced to make a circular argument. It says, why is this a qualification? Because we say it is. We say that this is a way to get rid of unqualified board members, the statute is. But it doesn't say how this statute conceivably sets a qualification. What is this qualification it sets? A qualification, for instance, as you're referring to, Justice Namias, about a conviction of a felony. The statute, certainly the General Assembly does have the authority to set additional qualifications beyond residence, which is what the Constitution mentions. It does that under several code sections. 20-2-51 sets various requirements concerning not only residence but employment. 20-2-63 sets requirements regarding conflicts of interest. So a board member cannot be elected if they already have a direct family member sitting on the board.
Mr. Cox, do you argue that the qualification, though, must be set out somewhere? It must be a finite qualification? And if not, what would be one that might be permissible?
Well, certainly a qualification that would be permissible would be one that required, let me come up with one that the General Assembly has not done. A qualification that school board members have a college degree. I think that would be considered a very reasonable qualification that the General Assembly could set. It hasn't done that, but what is the very nature? You have to, I think, to get at this issue, you have to look at what is the definition of a qualification, or what are the characteristics of a qualification. I would say a qualification, to be meaningful, it has to be objective, it has to be uniform, it has to be clear and knowable, and it has to be applied on an individual basis. What this statute does doesn't meet any of those criteria. An individual board member can do absolutely nothing wrong, can do, in effect, be the most conscientious, competent, serving board member conceivably. Yet if this private accrediting agency says, oh, we think the board, there are board governance issues with this board, then that board and every member of it is subject to this statute, suspension under this statute.
Are you combining in this argument local control and due process for the board members? Are you combining those in one argument here?
No, what I'm talking about,
separation.
What I'm talking about now is purely the question of what a qualification should be. But again, the reason I laid out the 7 items first is because each one of those relates to both why it's unconstitutional under local control by elected board, why it's not really a qualification, and why it violates due process of individual board members.
Assuming there's a qualification like, for example, residency.
Yes.
Is that just a limitation on when you start the office, or do you need to maintain, can the General Assembly provide a removal process if your status changes? For example, you're not an employee of the school board when you get elected, but then you take a job with the school board. Can they set up a removal process?
Yes, certainly, particularly if there is notice at the time the board member is elected that maintaining residence is a qualification. That is the case. This particular statute, I just submit there is no way it could conceivably be deemed a qualification. And we tried to come up with a suggestion in the brief of how that qualification might be described if it were one, and it's had to do with, well, you have to sit on a board that doesn't get put on probation by a private agency, but that doesn't necessarily apply if the state board doesn't conclude that it's grounds for your particular suspension, or if the governor decides after a hearing that that you'd be a better board member than the board member he's already replaced you with. That, again, if the court interprets the Constitution to define qualification that broadly, then I think it's basically reading out of the entire Constitution any requirement of qualification. What would prevent, for instance, the General Assembly from passing a statute that said the governor may replace all Supreme Court justices if the American Bar Association files a report that criticizes your decisions on the grounds that they don't comply with the public interest? The governor's only discretion there is to suspend all of you or none of you, and you can only get your jobs back if you prove individually at a hearing that you would more likely your service on this court would more likely satisfy the American Bar Association than would the person that the governor has appointed to take your seat. That is precisely what is at stake here.
Well, there would be one difference, which is in the judicial article, Article 6, there's an elaborate removal process through the Judicial Qualifications Commission, interestingly named not the Judicial Removal Commission, but the Judicial Qualifications Commission. And so arguably, where you have a very well-defined textual removal process, the General Assembly's limited. I was somewhat surprised by your answer that the General Assembly can set up qualifications and then set up a removal process for it as well, that's kind of implicit in the idea they can set qualifications.
Well, certainly that issue doesn't even have to be reached here. I mean, the question is this a qualification? If it's not a qualification, then, I mean, I don't want to try to defend ground that really isn't at issue. I mean, certainly an argument can be made that the court or that the General Assembly would not have that authority, but I'm not making that argument. I'm making the argument that the General Assembly is limited to establishing what is a real qualification.
You've emphasized the private entity. You have not focused on the Board of Education too much. Does that make a difference that the Board of Education is the entity that's actually holding the hearing?
Well, I submit that it should not, but to the extent that there is some action required other than we don't contest that there's some action required other than a private accrediting agency putting a school district on probation in order to trigger the statute. But at that point, what is it that the state board is hearing? Is it hearing under the statute whether any individuals have committed wrongdoing?
So your issue at that point is not whether there's a private entity or not. Your issue at that point is whether there are standards. Well,
I believe that it is unconstitutional to delegate that kind of authority to a private entity to even trigger the statute. The fact that no board member.
So, I mean, we have agencies that get audited by private accounting firms, non-governmental accounting firms, and you're saying so an accounting firm, you can't have a law that says, and if an accounting firm identifies fraud, that triggers some process where state entities then decide what the result of that process is.
Yes, I can say that an accounting entity that finds fraud cannot trigger a process that the first step of which is to remove all of the board members of a particular entity, that if it finds fraud as to a particular person, which this statute does not require, nor was it found that there was any individual wrongdoing. That's not what this statute says. It says if it just comes up with a status, says we're putting you on probation, that all of the board members are subject to suspension.
But if it were individualized, then it would be okay. If a private entity found information, there was a statute that says, if a private accounting firm shows that someone's committing fraud, then this process will be commenced.
As a hypothetical matter, I don't know the answer to that, but I think it's possible, yes.
Okay, well, and on the individual question, while the entire board is removed up front, potentially, assuming various things are found, no one is actually removed from office until they have an individualized opportunity for a hearing. So I'm not quite sure. You seem to have to overcome a second hurdle, which is whether a temporary removal from office on kind of a group is a violation of something.
Well, no, the supposed temporary removal effectively is a removal. These board members get their very modest individual compensation, but they cannot vote on any action. They are replaced on the board
temporarily, and then they can apply for reinstatement.
They can apply for removal, and the standard they have to meet at that point, again, has nothing to do with whether they've committed any individual wrongdoing.
Well, help me with this portion of it. What we try to do is provide some kind of stability. There's a presumption of constitutionality of statutes in this instance. What would an affirmance of this procedure, what impact would that have on constitutional officers in this state? Could this same format be used to remove any constitutional officer in this state?
Well, in the absence of a specific constitutional prohibition on that, I think would be the state's argument. I don't want to state their position for them, but yes, I think other constitutional officers, the General Assembly could pass a statute about the governor, about other constitutional officers, and say, we're going to, although the governor's a bad example because at least there would be a single individual that would be targeted. But here, the removal, what the board member has to prove under this statute, if it's faithfully applied by the governor, is not that the board member is a competent board member. It's not that the board member did no wrong. It is that the board member is more likely to please SACS, the accrediting agency, than is the person that the governor has already appointed to replace them. Now, if that's the standard for hanging on to a constitutional office.
What's the actual language in the test? I think
the actual language is that the reinstatement hearing
it's more likely than not to improve the ability of the local school system.
Whether the governor this is the only relevant evidence. Evidence relative to whether the local Board of Education member, singular, continued service on the local board is more likely than not to improve the ability of the local system to retain or reattain its accreditation. Again, nothing to do with whether that board member has committed any wrongdoing. I'd like to reserve my remaining time.
You don't think that the loss of accreditation by a school system is potentially wrongdoing? If a school board intentionally tried to lose the accreditation of their district through malfeasance, purposely tried to do it, you would say that's not wrongdoing because it's a private agency and accreditation doesn't matter?
Are you saying if an entire board did that?
Yeah, the entire board
or if a single individual
purposely sets out to do it.
Well, first, state law doesn't require any school system to be accredited.
I understand that, but
second, if that required a proof that the individual board member set out to do that and did it, that would be a very different situation than we have here. Again, you're asking me to defend a position that is certainly far beyond anything this statute did. At least it would be particularized. If there were 5 board members that were trying to do that.
But it is particularized, as you just read, on the back end, and the permanent removal, not on the front end, but on the back end. The permanent removal is more likely than not that individual board member will create accreditation problems.
Yes, but this is an elected constitutional official. That's
a different argument you're shifting to. What's the problem with that standard?
The problem with the standard is that it sets out a requirement for hanging on to a board position that has absolutely nothing to do with that individual's even impact in that accreditation decision in the first place. It's totally irrelevant then.
In the 30 seconds you've got left, you've got two cases from this court, Gwinnett County versus Cox and Robert versus Dio. What do they require us to do, since that's recent? Those are recent decisions from this court.
What do those two particular decisions require you to do? They require, I believe, for you to conclude and answer the certified questions that this statute violates the Georgia Constitution in all three of the respects that I have laid out, that it infringes on the voters' the right to choose an elected public board, and it infringes on the guarantee of an elected public board. It does not set any qualifications for that board membership as under any reasonable definition of that word, and it clearly violates due process under any reasonable definition of due process. Thank you.
Thank you, Counsel. Mr. Ritter?
Thank you, Madam Chief Justice. Justices, may it please the court, again, it is my honor today to be in front of the court representing the governor as well as the State Board of Education. This is an unusual case in the sense that
We have the two subsections of it. You're going to address those with specificity, I would assume.
I will do so, Your Honor. It is unusual because we have these certified questions. We're traveling on a record developed in a federal court as well as the administrative record, which I could not find on file with this court and may need to supplement with that, but it was certainly filed below, which would show the extensive process provided to Appellant Walker in this case. Now, the questions in this case first ask generally whether OCGA 20-2-73 somehow violates the Constitution, then specifically asks whether it removes a management control of a local board of education, and secondly, whether it exceeds a General Assembly's authority to pass legislation governing the qualifications of members. Let me take up that second issue first, mindful that this court, in addressing these questions, is going to be specific in answering the questions that have been asked. Taking up the
Counsel, before we get into the constitutional questions, can you tell me in Code Section 2273A1, who is an eligible member?
Undefined in the statute, the governor found in the footnote, which is found in the record as an exhibit to the amended complaint, which I believe is, I don't have the document number written down, but I can tell you it's 19, I think. The governor found that an eligible member was a member who was on the board at the time the conduct that led to the potential loss of accreditation arose. There were 9, in general, board members on the DeKalb County Board of Education. 6 of those members were present at that time. 3 of them subsequently were replaced after the dates of the accreditation issues with SACS arose. Because of that, those 3 members were found not to be eligible. There certainly was an issue, and I don't know that the statute answers this, nor do I know that it's really a question before this court, but I will say there certainly was an issue whether it was appropriate to determine whether those were eligible members or not. And the question really came down to, what does this word eligible in the statute mean? To give it some meaning, it was determined that that must mean the members who were subject to leading to the potential loss of accreditation.
Why doesn't it have the meaning in Section C that the code applies to all Board of Education members regardless of when they were elected or appointed?
I think that would be for ones, of course, in subsection C that are already presumed to have been suspended. So they wouldn't have been eligible in the first place. As you'll note,
that's not what it says. This code section applies to all board members regardless of when they were elected or appointed.
I understand. But, Your Honor, Justice Namias, we take the whole statute in paramateria, and if you look at A1 and A2, A1 applies post April 20th, 2011. That only contains the word eligible. A2 applied to April 20th, 2011 and before. So, and that doesn't contain that qualification of eligible because everybody would have been eligible in that instance. When you get down to C, you can see that only ones that have been suspended would be subject to that reinstatement provision in C, so that would be all of those board members. I would agree, statute could be clearer, but I think that if you read it as a whole, A, eligible, meaning that it applied to the SACS provisions as interpreted by the governor, and B, C, taking in all of those individuals that would be governed by that procedure, are consistent with the way the governor's read the statute. Going to the word qualifications, there are two issues that Dr. Walker raises regarding qualifications. First, he says that there is, in fact, no qualification contained at all in the statute, in the sense that he doesn't claim that the suspension, potential removal of these members is a qualification, and he says that it's undefined in that regard. Let me point out, as I think following on Justice Namias's questions, first of all, subpart A bases this qualification on the potential loss of an accreditation by an accrediting body. Being a member of a board that led to that potential loss of accreditation is a qualification, but it only is a suspension in that case. The impact on Dr. Walker and others in that situation is de minimis because they are only suspended with pay with a rapid full due process hearing. In fact, in this case, they're given somewhat of a double due process because there was a full contested hearing below just for the suspension, which was held in front of the State Board of Education. And then after that full hearing in which they were able to call all of their witnesses, cross-examine witnesses, had an independent officer who heard the evidence with a recommendation to the governor, who then affirmed what the State Board recommended, they would still be entitled to individual process after the fact before they are formally removed from office. That potential reinstatement or formal removal from office has extensive process, but without getting into the due process issue, as Justice Namias pointed out, it plainly turns on the qualification issue of whether their actions caused this school district to potentially lose accreditation. That conduct is a type of qualification. The General Assembly, by having the power to determine who is qualified, has the power to determine who is entitled to hold office.
And set up a removal process that's not listed in the Constitution?
That's true, because it says that they may establish qualifications as provided by law.
Let me ask you two questions on that. One is, in the education article, there are 4 offices that are created.
Sure.
The state school board, the state school superintendent, the board of regents, and the local school boards.
Correct.
2 of them expressly give the General Assembly the authority to create qualifications and removal from office, the 2 appointed offices. The state school superintendent and the local school boards just say qualifications. Mm-hmm. What are the words, and why have the words "and removal" in those other 2 provisions if you say you don't need them? Qualifications implies the ability to create a removal procedure. Well,
I'm certainly mindful of that issue, but I can tell, Your Honor, as you yourself pointed out, there are other places where the Constitution describes qualifications as an aspect of removal.
Right, but those are like the JQC, but that is in a provision entitled removal and talks expressly about the removal authority of the JQC.
That is true, but nonetheless, just because they specified in one place the word removal does not mean, obviously, that they were limiting the ability to remove in other places. For example.
Well, then what do the word, doesn't that render the words "and removal from office" in 2 of the 4 provisions of Article 8 superfluous? If qualifications includes removal, then why do 2 of the 4 provisions back to back, 1, 2, 3, 4, 2 of them say "and removal," qualification removal, 2 of them say qualifications, you say the words removal are nothing?
I can tell you, Your Honor, I think there are instances where there are superfluous words in the Constitution, as you're aware, and while I'd like to not read those words "and removal" out of existence, the reality is they do not have existence other places in the Constitution. For example, and we take the case Eves versus Harris, which is the primary case controlling in this situation. That case, in fact, passed on whether this power to set additional qualifications for office encompassed the idea that you could suspend, as here. That case involved Article 2 to start with, and involved a felony conviction. But Article 2 only refers to felony convictions. And in Eves, they were addressing suspension before conviction. Very similar process to what occurred in this case, because in Eves, the suspension occurred with pay, so there was a de minimis impact on any due process right or property right in that. And the court said at the end of that decision, that same provision of the Constitution, Georgia Constitution, Article 2, Section 2, Paragraph 3, also provides that the legislature may establish other qualifications for office, and thereby furnishes authority for this act. That's the Eves decision at page 6. So the fact that there was a provision for removal involved in the Eves case, that would have been post-conviction, did not prevent the word qualifications for also allowing suspension and potential removal even before conviction. Eves has already established this principle. And I note that in holding that, Eves also answers the appellant's question about whether this is a qualification at all. Because an action that happens by a third party outside of the realm of the governmental offices can lead to a disqualification from office, and that can arise while one is holding office. I think Eves cannot be interpreted otherwise, since it says so much as that.
How clear are the standards by which the board members will be judged under the statute?
Justice Melton, I'm not sure how to answer that question. How clear? They are clear enough, but we could always have more process.
Do they have to be more specific than saying whether they violated the standards of this private entity?
No, they do not. They are adequate to say that if they have, as it says here, led to a potential loss of accreditation, that's specific enough.
Counsel, what do you say to Dr. Walker's argument that to amount to a qualification, it has to be something that's personal and individualized?
Well, let me start with pointing out that Dr. Walker's argument about qualifications makes, and frankly about the whole statute, makes an assumption that is incorrect. It's the difference between malfeasance and misfeasance. They are assuming, and in fact counsel said, that there had to be some proof of wrongdoing. That is incorrect. The statute is not punitive in nature. This statute is about protecting the schools and the children in those schools. So the answer to that question is, if there is some sort of conduct, even if it's merely negligent conduct, that would lead to the potential loss of accreditation, that is sufficient to lead to that. It doesn't have to be proof of wrongful conduct on the part of the school board member.
But does it have to be personal or individualized negligent conduct?
Well, I think in this case, we would expect that it would have to be personal in the reinstatement proceeding. In the suspension proceeding, which is a summary proceeding, when this issue first arises, it's an emergency type proceeding. It's not particularized because the evidence about particularization hasn't necessarily been gathered yet. I speak in the general theoretical case because in this specific case, the SACS report was somewhat detailed, and I think that there was certainly grounds in this very lengthy 12-plus hour hearing about particularized conduct by different individuals. However, the statute does provide for the initial part of the hearing to be against all of the school board members. But the idea that it violates due process to do that is incorrect, because that impact on whatever property right they have is de minimis, and they have a right to particularized hearing about their own conduct. In fact, it's not in the record, but I will state in my place that there are hearings right now scheduled administratively for many of these individuals. Will start on the 13th of June, and I think they can continue on consecutive days. Each one is having a separate hearing.
Does it matter if SACS standards are not fair standards, or if SACS has acted inappropriately? Is that subject to what can be heard?
I think that if the evidence that SACS relied on was not evidence of individual conduct at the reinstatement proceeding, the ones that are coming up, then, of course, there might be a right to reinstatement in that instance.
I'm
However,
talking systematically, not just in this case.
Right.
If the statute relies so heavily on SACS, what if somewhere down the road SACS acts inappropriately or uses criteria that shouldn't be applied? You know, what's the safeguard there?
well, I can tell you that we need to start with the obvious fact that SACS is not the only accrediting body. And they chose to have SACS in this case. If SACS were proven to act in a way that is inappropriate, then they could choose to go to another accrediting body.
Is that subject to what can be heard at the hearing?
Well, at the second hearing, I certainly think that SACS arbitrary conduct is something that can be heard. And I think that if the school board were to hear about the disaccreditation based on arbitrary and inappropriate conduct by SACS, it would not recommend suspension of the entire board to the governor. This is not a statute that calls for potential loss of accreditation and ipso facto then the governor suspends the members. Rather, there's a hearing in front of the school board, state school board. They then make a recommendation, which is independent, that goes to the governor, and the governor then adopts or rejects that recommendation. So if your concern, Justice Melton, is about whether SACS acts inappropriately in some manner in its disaccreditation, potential disaccreditation in the early stages, that can be rejected by the state school board, and it can be rejected by the governor. That is as to the initial suspension. And if it acts inappropriately as to individual members, then each one of those individual members can raise their concerns about that or present contrary evidence at this full APA-style hearing that is subsequently held should they wish to be reinstated.
Can I get, I'm sorry, go ahead.
Is your argument that due process is met because the hearing takes place quickly? Is that the?
No, my argument is that, first of all, we have to break the due process issue down into the separate things that the statute does. For our purposes today, there's suspension and then potential reinstatement. And Justice Namias, I think, just unintentionally referred to the first part as initial removal. It's not. Suspension with pay. That's quibbling, perhaps. But I will point, there's different due process issues for each one of those. As to the suspension issue, due process is met because they are entitled to have some sort of hearing before suspension. They have notice and an opportunity to be heard, and the issue arises based on the qualifications issue based on subpart A1. And the injury to their property right is de minimis, as in fact Eves held and Matthews versus Eldridge in other cases, because suspension with pay does not require extensive process. However, for reinstatement, we have a much more elaborate process that I think is plainly satisfactory as procedural due process. And that is that you have the right to an APA proceeding where you have the right to call all of your witnesses in front of a disinterested administrative law judge. In fact, Chief Judge Max Woods is hearing these cases. And then you have a right to have a decision on that and then the right to appeal that decision. So there is, in fact, extensive process that's provided for the reinstatement issue. In this specific case, and I'm mindful that you have certified questions which are perhaps broader than the specific facts, but in this specific case, I think you would see, based on the citations I've provided in the brief and the full record in this voluminous hearing, that they probably had adequate process for the entire case presented on the front end.
Can you go back for a moment to the removal issue?
Yes, Your Honor.
In the judicial article, it's the only other place in the Constitution I saw that the General Assembly can provide for additional qualifications of all judges in Georgia. Mm-hmm. Now, there is a JQC process for removal, and judges can be impeached. But it seems like by your argument, the General Assembly could, for example, the hypothetical Mr. Cox said, the ABA says they don't like the opinions of the court. The Chamber of Commerce says the opinions of this court are bad for business in Georgia and will create an actual harm. And so they set up a process where, you know, the exact same process for removal based on the standard of, you know, judges are not deciding cases in a way that more likely than not will be good for economic development in Georgia. Why would that not pass the test under your approach?
Well, first of all, let me point out that you have seen it in the judicial section of the code, but again, returning to Eves, if we look at Article 2, which involved local legislators, that not only had felony conviction back in 1988, but also had the qualifications as provided by law, and they found that to be allowing removal. But coming over to the specific question about whether this, a parade of horrors could arise if the General Assembly is given too much authority, I can tell you that it is the practice of this court and the law in this state that the General Assembly is given great deference and authority, which I think is beyond the pale of being able to be questioned. That doesn't mean, however, it can act arbitrarily or they can act without any rational and reasonable basis. It's long been the law that you cannot, even when you're given broad plenary authority to act irrationally or without due process.
Well, what would be irrational about saying the decisions of court, just like the decisions of school board members that hurt school children's accreditation and the economic, and there's a lot in the record about the economic situation of a county whose school board loses accreditation, the decisions of a court that hurt economic development in Georgia as determined by pick some agency, and therefore the General Assembly in its wisdom, it wouldn't be irrational to say you can remove judges who decide things that way.
Mr. Ritter, you can answer that question.
Thank you, Your Honor.
And then your time is up.
Yes. The specific answer to that question is, it is the General Assembly's authority to make that decision, to decide. If you agree that it is rational for them to do that, then I would suggest if they have the powers to decide qualifications as decided by law, that indeed would fall within their authority. Thank you, Your Honor.
Thank you, counsel.